All right, everybody. Well, welcome to our first Legalese show of the year. Stephen Palmieri is normally with me, and he is tied up today. So it will just be me. And I may have a friend of mine, Blaine Dixon, who's a great consumer lawyer from Tennessee, on. We're trying to work through some technical issues right now. So if we get that worked out, then he will join us. But however we do this, the main purpose of this live show on Facebook and on YouTube is for you guys to be able to ask questions and just put in the comments, and then we'll take those comments and we can put them up on the screen, and then we'll try to answer those as the best possible way that we can, and hopefully you'll get some very good value out of this. So while we're waiting for some comments and also seeing if we can get the technical issues handled here, just wanted to share a couple things with you, just sort of bring you up to speed on what's been happening recently. So, hey, Stephen, this is my co-host who bailed out on me, but he's apparently still around, or maybe this is a bot. I'm not sure. But if this is the real Stephen Palmieri, we miss you, and we'll catch you in a couple weeks here. So we've chatted in a few of these about Regulation F, which that is the new rules for the FDCPA, Fair Debt Collection Practices Act. And those are in force. And so there's some really neat stuff with that. Of course, the beginning of the year, a lot of times we all do New Year's resolutions and say, hey, I'm going to get this in order, or this in shape. And it's a great time, if you haven't done it, to pull your credit reports and to get your actual credit reports from annualcreditreport.com. And I will see if I can put that up on the screen here. And so if you go there, really, you just go to annualcreditreport.com and you'll see where to pull your reports. It's so critical to have your actual reports. So this gives us the most data for every account. And so what we do is we look through all the negative accounts, and we want the most possible data, because that gives us a chance to find all the errors. If we use something other than our real reports, we may only have, for example, 2 years worth of information. And even then, it's not really the full 2-year pay history. And so when we can get that full pay history, where we're getting the balance and the credit limit and the amount past due and the rating, are we 30 days or 60 days or current or charge off, the more data we can look at, the more errors we find. And what we're trying to do with correcting our credit reports is to find all the errors and then dispute those errors. And either it gets fixed, it gets deleted, or you look at suing whoever's responsible so that they will fix or delete it and pay you and your lawyer money. So that's one reason why we want the real credit reports. The other reason is we want to make sure we have the actual information. So it's one thing, like take Steve, for example, Palmieri. If I said, well, this is what Stephen Palmieri says. Well, maybe I'm right, maybe I'm wrong. And so if you want to know what Stephen says, you talk directly to Stephen. Well, if we want to know what Equifax says about us, go directly to Equifax. We don't go to Smart Credit or Identity IQ. We don't even go to Experian or TransUnion and buy a 3-in-1, because that's what they say Equifax is reporting on us. If we want to know what Equifax says, we go directly to Equifax. Same thing with Experian, same thing with TransUnion. And we do that through annualcreditreport.com. Let me see here. Blaine, are you with us?
Yes, I am. Can you hear me?
Yes. Yeah. So we were, it was working where we could see Blaine and hear him, but he couldn't hear us. So, which, depending on what I say, might be actually an advantage for Blaine to mute me here. So, so anyway, good to have you, Blaine. And
thank you. It's good to be here.
So Blaine and I do a lot of work together. Blaine is in Tennessee. And why don't you tell everybody, Blaine, what type of consumer work are you doing?
Typically, I represent consumers who are either victims of identity theft, or there are errors on the credit reports. And perhaps you may be someone who's disputed an item on your consumer disclosure, only to find that they continue to put you off and not take you seriously. I also represent many people around the state in debt collection defense, and so it's a variety of areas, but those are the areas that I'm primarily focused on here in Tennessee.
Okay. And Blaine and I do very, very similar work. And so I do mine in Alabama. He does his in Tennessee. And so, of course, you can ask us anything. And if it's really hard, I'll make Blaine answer it. If it's easy, I'll take it. And normally I make Steve answer all the tough questions, but Blaine will do that here. And but in all seriousness, the three areas I would say would probably be the best to ask us about would be sued by a debt collector, dealing with debt collectors, maybe they're being abusive, and then anything with credit reports. So we're happy to answer any questions that you guys have. And let me see here what we have. So Victoria says, hey guys. So, hey, good to see you, Victoria.
Nice to see you.
And let's see, check my email. Let me know an update. Victoria, I will do that. We have been in a trial this week and actually some last week. So I am still unbearing myself from this, a lot of stuff trying to just catch up. So I will check that. I don't recall seeing an email from you, but I may have missed it when we were in trial. So either let me check on that, or if you don't mind, just forward that to me again, and I'll get right back with you. And let's see, we have our friend Timothy Williams here. Facts. I don't know if that was about the credit reports or about it being better if nobody could hear me. So it could be either one with my friend Timothy there.
Hi, Tim.
And then we've got Sam here. Hey, y'all. Good to see you, Sam. And Sam's doing some credit repair in, if I remember right, Sam is at North Carolina, I think. And so good to see you on here. And let's see. Elisa Clement says, what do you do about an account in good standing that has not reported your positive payments for almost 9 months? I've written letters to them asking them to update my payments, and they have not. So here's what I would say about that. Let me make sure that we're understanding the question. So there's two possibilities here. One, you have an account that you're totally current on, and they're not reporting anything on it at all. The other possibility is they reported some stuff, maybe negative stuff, but then they just stopped reporting. It's just sort of frozen on your report. They're not updating it every month. So the first example where they just aren't reporting at all, unfortunately, you can't make somebody report. It's all voluntary. So they might report to all three. They might report to two. They might just report to one or none. And a furnisher, to somebody who provides or furnishes information to the credit bureaus, can decide, I don't want to furnish. But if they've reported some and now they've just stopped reporting, then you can dispute that with the bureaus and say, hey, tell them to do their monthly reporting. The one exception that I'll mention, and then Blaine, add anything that you have to this, is if there's been a bankruptcy, sometimes they sort of freeze the reporting and say, well, let's figure out what's going on with your bankruptcy before we do any more reporting. So that would be a question I would have for you. And Blaine, do you have anything to add to that?
Well, it's important to note, as John said, that their failure to report at all that's not something that we can take action on. However, if they begin to report, they are required to report completely and to use maximum efforts for, all reasonable efforts for maximum accuracy. And in the event of a bankruptcy, not only is there a freeze, but let's say, God forbid, you happen to have to file for bankruptcy protection, then when on the backside of that bankruptcy, when you've received what the court calls a discharge, then there are certain requirements of them in terms of accuracy of reporting after that. But for the sake of this, I believe John has covered all the bases.
And let's see, we've got a little bit more information. Okay, so no bankruptcy.
Okay.
And they have reported in the past, but they've stopped. So the one thing that I would just caution you about, and it's not to discourage you, is just make sure you know sort of the full situation here. Anytime we dispute errors, so it could be inaccurate, could be incomplete, could be they've stopped reporting, whatever it is, they always have the option to just simply delete the account. Okay. So I always tell my clients, never dispute something that you're not comfortable being deleted. In other words, we can't say, well, you have to fix this one thing, but don't delete the account. We can't do that. They can just choose to, you know what, we can't get this right, so we're going to delete it. So there is a principle that if you're still actively have an account, in other words, it's not been closed and charged off and all that stuff, that they do need to report that every month. And so let's see here. I think here's the final part. Do I contact credit bureaus? Yeah, I would contact them. And I prefer to do it in writing by certified mail. And I think Blaine does the same way but you can do it online. Okay. You just need to keep a record of what you do and say, hey guys, XYZ account is not reporting. They're not updating. I want you to get them to update and then see what happens. And let's see here. Counts over 16 years old, student loan paid on time every month. So, there's a time limit for negative accounts. In other words, negative information should fall off in 7 years. But, we could have a credit card, for 30 years and it should be reporting every month as long as it's an active account. So, let's see. Do not want the account deleted. Good positive paying account. In that case, what I would say is I would send a certified mail letter to the student loan company first and just say, hey, I'm confused why you're not updating my report, and maybe give them a printout. I know it's sort of silly because it's their own records, but give them a printout from their own website of all your payments being made and say, can you guys update this or tell me why you're not updating it? And that might sort of jog somebody's memory to say, oh, okay, we need to fix something. It could be that it got miscoded as a bankruptcy, or maybe like a cosigner filed bankruptcy, or they think one did. And that's why they've stopped the reporting. But you definitely want to get the benefit of the positive reporting. Just keep in mind, if you dispute directly with them or the bureaus, there always is the chance that they delete that. So you are very welcome and great questions there.
Excellent.
Let's see here if we can go back up and let's see. Victoria spoke with your receptionist. Okay. Yeah, I'll check on that, Victoria, and feel free to call in. Probably you spoke with Carolyn or Caitlin, and so if you don't hear back from us, just call them. And I think Carolyn's out today with somebody's having some surgery that she's taking care of. Let's see here. Okay, Log Home says, will these junk debt buyers still sue people 2 years later? So, Blaine, I'm assuming that means 2 years after maybe defaulting on a debt. And so what's the lay of the land in Tennessee? What's the time period debt buyers like
in general
Airbnb that they sue?
Well, John, I hate to use the old in law school, the answer that the professor always would give that would make you crazy is you would ask him a really serious question. He would say, well, it depends. And it depends on a variety of factors. I can share with you that from experience with my clients and having done this for a while, that in really, really tough times, sometimes they actually sue sooner. They have a statute of limitations in Tennessee on most of these debts of 6 years. But if I were receiving letters, demand letters from a collector, before I was in the profession, I might have frozen. But I would always say that the best suggestion to anyone who's begins receiving communications is to go ahead and talk to someone like myself or John and be proactive rather than reactive, because you don't know. They may send you a letter. They may send you a letter every month for 6 months and then sue you. It may go on a couple of years. They may go silent. I've had people call me and say, "Well, I received letters and phone calls from a collector on a certain debt, and then they stopped." So I thought, "Oh, great, it's gone." But it's no, it's kind of like a lot of problems in life. It may be silent, but it may not be gone. And so, your best advice in the situation of an encounter with a collector is go ahead and call someone and begin to have discussions on how to deal with that, and expect that you may have to answer a suit on that.
And what I put up on the screen and in the comments, I'm not sure exactly how this shows up in the comments, but this is a website. It's called Naca, National Association of Consumer Advocates. And if you go there, obviously it's better if you can click on it, but if you can't, just go to consumeradvocates.org and you'll see a place for Find an Attorney. And you can find somebody in your state that deals with collection type lawsuits or even just debt collectors. And so if you're in Tennessee, call Blaine. I'm happy to talk with you in Alabama. But if you're in another state, check that out, talk with some people, because sometimes there's different strategies that apply. Sometimes we want to do nothing because we're maybe really close to the statute of limitation in your state. Other times we want to be more aggressive with the collector and sort of put them on the defensive to give us some information. And it really does depend. But the best thing is don't ignore it. And obviously you're not ignoring it because you're asking us about it. So that's great. And I would just make sure that you're taking some action, keeping an eye on your credit reports, keeping an eye on any letters you're getting, any phone calls, any emails, text messages about this. And you sort of want to gather all that up, talk to a lawyer in your state and say, is this legal? Is this illegal what they're doing? And, there's not always a great answer, but you certainly will get the best answer when you have as many of the facts gathered together as you can. So let's see here. So thanks, guys. Well, you are very welcome, and thank you for the good question there. Let me go back to, and if you put a comment in and I don't answer it, it's not intentional. I'm just trying to sort of scroll back and forth and find these. So let's see. Victoria said, have a student loan discrepancy as well, reporting multiple incorrect, inconsistent late payments. Dispute to my eyes are blue. Yeah, so it can be frustrating, when we find those errors and we dispute. The trick is we want to give the credit bureaus and sort of through the credit bureaus, the furnisher, we want to give them every error, make it easy, simple, plain. They can understand it so that either they fix it or they delete it or they choose option 3, which is please sue me because I want to delete it and pay you money. Now they don't think there's an option 3, but that's their option 3. So you want to make sure that your letter that you've got, that you've sent to them is so clear that a judge reading that would sort of look at the credit bureaus, look at the furnisher and say, guys, seriously, what was hard to understand about this? And that's how you want it to be. So you may have already done that, Victoria, or if you haven't, you just want to go back through your letters and make sure that you made it crystal clear what the errors were and why these were actually errors. So let's see here. We have Alicia Clement. One more question. My credit score is around 714. However, I have some paid charge-offs I really want to get removed. Is there a legal way to do so? I think they're hurting me with credit companies. So a couple of thoughts, and I'll take sort of the initial stab at it, then Blaine will clean up everything I messed up on this. One thing is, and I totally understand what you're saying about your credit score. Keep in mind, there is no one credit score. There's two companies. There's Vantage, which is basically the credit bureaus, and then there's FICO. But within particularly FICO, there's all different versions of scores. So you kind of want to know, if you're looking to buy a house, what really matters is the FICO scores that relate to your mortgage. If you're wanting to buy a car, you want to look at that. So generally, a 714 is very good. Okay. Now, these paid charge-offs, the way that Blaine and I approach this is anything that's negative that has errors, we want to challenge that. Okay. So whether it's paid off, whether it's not paid, if it has errors, and as long as we're comfortable with it coming off our report, and obviously these you would be comfortable with, then we challenge it. So for example, we just did some dispute letters recently on a paid charge off, and we paid it in, let's say, October. Well, if we paid it in October, how much did we owe in October? Well, my way of thinking, we owed zero because we paid it in the month of October. Well, then in November, they show it that we still owe a balance. Well, how do I owe a balance if I paid it in October? I can't owe a balance in November. And they said a charge off in November. Then December, they said zero balance, charge off. How can I be a charge off if I have a zero balance? I mean, you can't be late on zero. So the point is, you can look at the moment it was paid off and the months afterwards, but also look just all through there. Are there any errors? And that's what we look for. Blaine, what else would you add to that?
Well, my only addition to that is it's absolutely critical that when you dispute, that, as John has pointed out, that you dispute no uncertain terms, in clear and concise language. Over here in this month, see, I paid this off. It's literally not possible. What we've experienced, what the judges want to see is what we call an objective error, where it's, we're all familiar with the term, it's right there in black and white. There's no ambiguity. There's no gray area. There's no question. The account was paid in full, and anything past that is improper and inaccurate, and will negatively affect you. So I think absolutely, just be just as clear, and you don't have to be wordy. You're not writing a song or a novel. You're getting a point across. As one of my mentors who I worked for when I worked for the state legislature told me, we were writing bill summaries. He said, it's important to remember, they don't care how pretty it is. They want to know the issue in black and white. So be very straightforward when you write these disputes. And just point right, know where you're looking at and know how to direct their eyes right to the spot. If you have a copy that you're sending them in a dispute letter, you may take a highlighter or a pen and draw a circle around the affected area and say, see here in this month, see where it continues past the date where I paid it off. Make it visual, make it easy to understand, and you can't go wrong.
Yeah, and the other, just sort of a couple quick follow-ups. You don't feel like you have to quote the law. A letter is no better because the law is quoted. Okay, it's no worse if it's quoted. So what you have to do is tell the credit bureaus what's wrong. Okay, now they know what the law is, and if they don't, that's their problem. So what you're trying to find are, like Blaine said, these objective errors. So see, it's one thing if I say, hey, that 30-day late from Discover is wrong because I had a phone call with Pam in customer service and she said I could skip a month. Well, how does Equifax know that? They don't know that. Okay. Now, Discover might, if it's a recorded call or it's in the notes, but we want to put things before the credit bureaus primarily that, as Blaine said, are in black and white. I mean, like, here's an example. Date of last payment is, January 5th, 2020. Amount of last payment is zero. What in the world is that? Like, how do you have a zero payment? Okay, so they're not relying on some mysterious conversation you may or may not have. You're like, look at your own credit report, TransUnion. It doesn't have this correct. So you just want to make it easy. It doesn't need to be wordy. on the other hand, don't try to make it short. There's a sort of an idea in marketing. How long should a video be? How long should a letter be? How long should, any type of sales presentation be? As long as it needs to be, no longer, no shorter. Okay. Just do whatever you need to do to make it clear to them. And so I've seen some people are like, I must fit everything on one page. Like, no, we're not like worried about saving paper. Just make the errors very clear to them, and that'll put you in a good position. Let's see here. So Kim says, very easy to understand, listening to advice. Well, you're very kind, and we appreciate that very much. And the Newman says, is the credit score industry ending soon? Not to my knowledge. Now, there's always been talk, particularly when Biden was running, and then a little bit after he became president, about that basically the government might take over the credit bureaus. I'll say this: I am no political expert, but I'm pretty confident that things are so evenly split right now that hardly anything is going to get done. And if history is any guide, the Democrats should lose a lot of seats in the House and maybe even lose the Senate. And so if you have Biden in the White House and Republican-controlled Congress, I would think very little is going to be accomplished. This would be a massive overhaul to take these, billion-dollar companies and say, all right, we're now taking control of them, and the government will run it. And that sort of drives the credit scoring. I don't know of any other sort of threats to the credit scoring industry. Are you familiar with any, Blaine?
I'm not. In fact, I would say that would be the most remarkable, indeed unfathomable decision that could ever come out of Washington from either party, considering the amount of money at stake. And one thing all of you probably know, you may not have heard it like this, is that, our economy is a credit-based economy. And the last thing that the Federal Reserve would want to see happen would be anything that would upend the credit markets. You've heard of consumer credit confidence markers. Plenty of times, during periods of economic uncertainty, you'll hear the term, well, consumer confidence has slipped. Well, couldn't be anything any more damaging to consumer confidence than for consumers to wake up one day and, the big three just be gone and the government taking over. I think that's not, we're not saying it's impossible. We're saying that all the indications it's extremely, extremely unlikely. I think in our country, from all sides, in all parties, that people are too independent to want to see the government running their credit. And I think Congress certainly is not about to do anything to change the order of things that drastically.
Yeah, and the other thing I would add is, nobody knows what the future holds, but it certainly appears inflation is running wild. And so basically the tool that the Fed has to control inflation is start raising interest rates. They've been artificially low. It's great if you're borrowing money, kind of terrible if you're saving money. But as those interest rates rise, that's going to make it harder. For example, think about a mortgage, harder to buy a house because housing prices are just wildly inflated right now. Then you add interest rates on top of that. So now the question is, the mortgage companies have to make sure that you can afford this. So it makes the credit scoring even more important. And so I think right now our economy is in a very dangerous position. And so I don't think either party will want to try to throw a monkey wrench in with taking over the bureaus or getting rid of scoring. Now, the last thing I'll say about it, there are some discussions by the CFPB and other regulators about inequities in the scoring and along economic lines, racial lines, all that sort of stuff. And so they are certainly looking at that, but I think that is to sort of tweak it, not to get rid of it. So maybe a much longer answer than you wanted, but hopefully that's some help there.
Well,
I'm sorry, go ahead, Blaine.
Well, John, it's important that they know. Are they aware of how many dozens or hundreds of scoring products are available? FICO has literally several dozens of scoring models, and then the consumer will see one score, but that's not necessarily the score that the lender is looking at. So it's easy to be deceived by a score you're looking at, particularly if it's a score you've received as a result of some free or low-cost credit monitoring product. So,
yeah, and let me just share this if I can share my screen. So this just came out basically today, or maybe within the last couple of days. The CFPB puts this out every year. It's a list of all the consumer reporting agencies. And of course, you have Equifax, Experian, TransUnion. Then there's one called Innovis and SageStream and LexisNexis. But there are just dozens and dozens of these. This gives you an idea of kind of the variety. You've got employment screening, tenant screening, check and banking, personal property, medical. That was kind of a weird one, Blaine, when I figured that out. And so I, said, hey, give me a copy of my medical credit report. It's kind of bizarre to see. You got low income, subprime, supplementary. So, I don't even know what gaming is. Gaming establishment. Oh, maybe that's like casinos and racetracks. So, I mean, think about this. There is a credit report on you for the purpose of casinos. I mean, years ago, we had a truck wreck case where we were suing a trucking company, and we got the DAX report, which is the credit report for truck drivers, whether they've been involved in wrecks. Has nothing to do with credit, but it's still called a credit report. So my point is, fitting with what Blaine said, there's a ton of these bureaus out there. So I don't think the government would take them over.
checks.
Yeah, all these things. So I'll put the link to this on here, and definitely worth checking out. Almost all of these you can get a free version of this. When I say free version, you can get a copy of your credit report. So I would definitely check this out. You've got here's the retail equation, free report. I mean, all of these will basically give you a free report once a year. So, all right, let me stop the screen there. So go back to our questions here. And let's see. So here's one about the FDCPA. So would you guys sue on a cease and desist letter where the language of the letter says, I'm no longer disputing this account, and the collector leaves it marked as disputed? Does that trigger an E8? So let me pull up section 1692E, and let me share my screen here just so we can all be looking at the same law. So this is the easiest place to go to, law.cornell.edu. And then we go down to E8. So E is any false representation. Okay. And then 8, so let me get this highlighted for us, is communicating or threatening to communicate to any person, which would include a credit bureau, credit information which is known or which should known to be false, including the failure to communicate a disputed debt is disputed. Okay. So the question is, if you send a letter to a credit or to a debt collector and say, hey, I no longer dispute this, but they don't change the dispute notations, does that violate E8? A couple of thoughts. One, E8 only applies to sort of when they update the report. Okay, so if they've reported on me and then I dispute it and they just no longer update, there's no E8 violation on that failure to mark as disputed. You're talking about kind of a reverse dispute. Blaine and I are familiar with these types of cases, there are some places that will dispute things, and then they'll go and sort of wrap your brain around this. Then they go to the credit bureaus and say, hey, I dispute the dispute because I no longer dispute it. So mark it as undisputed. Blaine, it's sort of like math, a negative times a negative equals a positive. Sort of like if you dispute a dispute, it's supposed to be undisputed. What the courts have pretty much said is that you have to go directly to the source, not the bureaus, but go to the source. So, for example, the debt collector, make it clear you no longer dispute it. I would even say make it clear that you're asking them, hey, update the credit report to show it as not being disputed. Then you may have a case. I would be reluctant to sue on that without knowing a little bit more. And because the whether it's right or wrong, judges have said, well, look, if it was disputed, it's disputed. You can't just sort of snap your fingers and undispute it, even though you really can. So I would be a little reluctant on that. I would be more interested, since it was cease and desist, did they communicate after receiving that letter? Did they call you, email you, text you, write you? Because that would be, I think, a cleaner case. Blaine, what are your thoughts about that?
Well, it's important to remember that, words do matter. We frequently say that in the law and consumer law, no less than anywhere else. I've been working with a client who was receiving communications on a debt that was no longer able to be collected on, and she had asked for. It's a Regulation F question. That's a little bit different from what we're dealing with here. But the point is, she continued to ask, and I had spoken with John, and he said, he suggested, well, the regulations are all driven by the word convenient. Have your client inform them that it's inconvenient. And as soon as she informed them that it was inconvenient, immediately she gets an email back from the director saying, we will never email you again. And problem solved. So what you don't want to do is go in front of a federal judge and I think what John is trying to say is if you're going in front of the court, you want it really clear. Again, it's back to black and white violations. You don't want anything where it's sort of half in and half out of the fog. You think you can see it, but you're not sure. You're not sure if it's a violation. I don't know if you've ever seen the movie Master and Commander. Russell Crowe's character in the beginning of the movie, they're looking off into the fog and they think they see the ship and the enemy ship, and no one sees anything, and they're about ready to go away. And finally, the captain looks one more time, and that's when he sees the flash of light, and they know to get down. You want a clear flash of light. If you're going to start throwing cannonballs at these guys, make sure you're in a fight before. And the best way to do that is to have black and white disputes. If you're not certain, you can always continue to analyze this and work on your communications with the furnisher of the information to the credit reporting agency, and continue to put them on notice, and they may well violate in a way that is able to be acted upon with a greater clarity. So just be careful. Those sorts of things, I probably would not on that alone file straightway, but would continue to work to try to clarify that line of communications with the furnisher of the information.
All right, good stuff. So here Timothy Williams says, can you explain reasonable possible accuracy?
John, that's yours.
So, let me pull this up, because what Timothy's talking about is Section 1681E. This is from the Fair Credit Reporting Act. So let me get this. And hopefully that is showing up here. So it's really a very small section of the law, but it's very powerful. So we call this, when we file suit on this is a 1681 EB claim here. And so the reason it's literally section 1681E and then it's subpart B. And so it just says whenever a consumer reporting agency prepares a consumer report, it shall follow reasonable procedures to assure maximum possible accuracy of the information concerning the individual about whom the report relates. So all that's saying is when Equifax decides to have a report on Blaine Dixon, it has to use reasonable procedures to do what? To assure maximum possible accuracy. Now, I will say this, most courts treat this as definitely a much lower standard than when you dispute. Okay, and let me clarify this. So think about it this way. These bureaus get, and I'm not saying I agree with this, but this is the rationale that the judges get. They're getting billions of pieces of data. Well, do they have to like check every piece of data for accuracy? Well, if you read the law, it kind of sounds like, reasonable procedures, maximum possible accuracy. But the courts say, well, until you put the credit bureau on notice, it doesn't have quite as high of standard. But when you pinpoint, hey, the Capital One account, and specifically these 17 things with that Capital One account, now they have a really great obligation to investigate. Now, this is not to say we can't sue under EB. So EB allows us to sue even without making a dispute. So we might, let me give you sort of the classic example. So let's say Blaine and I represent Joe Blow, and Joe filed bankruptcy, got a discharge in January of 21. And then in June of 21 and July and August, September, October, November, December, these credit cards that he had from 4 years ago are showing a balance and they're showing updated. But they also clearly show they were open before he filed bankruptcy. Well, the bureaus know if you have credit cards or medical debt or collection accounts that are before you filed bankruptcy, and they know when you filed bankruptcy because they report the bankruptcy on your credit report. Well, then if you've got a discharge, and again, they know that because they put on their date of discharge, well, they should know that those accounts are discharged and should be a zero balance. So we often do dispute that, but we don't have to dispute that. So there are some things that are very clear where, like the example of the paid off account, and it says, you paid it off on this date, but yet 2 or 3 months later, they're showing that you're late on this charged off account that's been paid off. It's like, wait a minute, guys, that's not even remotely maximum possible accuracy. But just as a general rule, and this is something I've followed since, the early 2000s, is we could sue sometimes under EB, but it's really better to send a detailed dispute to the bureaus and sort of focus their mind on this one account or these dozen accounts or whatever. And then that takes away a lot of excuses they have because they argue and sort of whine to the judge. Well, how are we supposed to know? We have 1 billion pieces of data every month coming in. But when your letter pinpoints exactly what's wrong, it takes that excuse away. So anything to add to that, Blaine?
No, I don't believe so. That's fairly complete answer.
Okay. Let's see here. Let me try to refine my place here. Let's see. I think this is where we are with Archie. I sent a dispute letter addressing 39 different errors to the 3 CRAs. Very little change. This was my 3rd round of disputes. And then I reached out to lawyers here and was told the bureaus are just repositories and I don't have a case with them, but the creditors. What are your thoughts? So it's very good to identify all the errors. Blaine, what would you say about this idea that the bureaus are just repositories, which they certainly are repositories, but
they are. But this is an argument. This is an argument that I've seen on the listservs, the bulletin boards within the consumer advocacy community. I don't think that so long as you dispute in the correct order, and you put the consumer reporting agencies, Experian, Equifax, TransUnion, et cetera, on notice with detailed, factually accurate, to the point disputes, that is not going to, absent John sharing with us that there's something radically different, that is not going to wash, or as they used to say in the South, for lack of a better word, that dog won't hunt. So I would encourage you to look closely at that with someone like myself or John, and flesh that out, because that's obviously, you spoke with someone who had either some level of authority or some sort of heightened level of knowledge. It wasn't a person on the bottom of the ladder, but that sounds an awful lot like sort of a brush aside argument that you might get from someone employed by the CRAs.
Yeah. It's just it's wrong. Okay. So this is section 1681I. So this is procedure in case of disputed accuracy. Now this is to the credit bureaus, because that's who we dispute, is directly to the credit bureaus. And so it says here, this will be enough. If the completeness or accuracy, which is exactly what Blaine and I have been talking about, there's something inaccurate, there's something incomplete. Notice this, any item. See, sometimes the bureaus say, well, you can't dispute your name. Well, I'm sorry, I got confused by the word any item. We can't dispute, that we have your phone number wrong. Any item, I think, includes phone number. Any item means any item. Okay, it's pretty simple. Any item contained in a consumer's file at a consumer reporting agency is disputed by the consumer, and the consumer notifies the agency, that's the credit bureau, directly or indirectly through a reseller. Such dispute, the agency shall, free of charge, conduct a reasonable investigation. And so that's their obligation. Then if they violate that, you sue them. Okay. So yes, they are a repository. They take all this information in. The furnishers all provide or furnish information to the bureaus, but the bureaus have their own obligation to see, is this information accurate, complete, verifiable? And if they violate that obligation, then you sue them. So let's go on to, let's see. Victoria says, can you give a little clarification on the violations and fines? In my example, if they are reporting 17 instances on each report of incorrect information, is that $1,000 for each one? So let's take a step back. Just because there's inaccurate information on your credit report does not mean they have violated the law. They violate the law when they do something negligently or willfully, also known as recklessly or wantonly. So think of negligence as this standard. Reckless, wanton, intentional conduct is a higher standard. Okay, so if I am driving and I look in the back seat and don't realize that traffic in front of me is stopped and I hit somebody, that's likely just negligence. But if I'm driving drunk, or if I'm driving with my eyes closed, then that may be recklessness or wantonness. So if a bureau gets to that higher level of intentional, reckless, wanton conduct, then you can get what are called statutory damage. Totally different than the FDCPA or the TCPA. We have to keep all these laws separate here. You have to prove willfulness or wantonness, recklessness, and then it can be up to $1,000. There's some debate, is it $1,000 in total or per violation? But if it's only negligent violation, you don't get that statutory damages. You can only get what are called actual or compensatory damages. So first step, we identify the errors, then we notify the bureaus of those errors, and then we see, do they fix it? Do they not fix it? If they don't fix it or delete it, then we say, okay, was that negligent? So go back to the example I used of me disputing a 30-day late on my credit report because I say, well, the lady at Discover told me in some conversation at some point that I could be late 1 month and they wouldn't report it. And the bureaus don't fix it. Well, were they negligent? No. How would they know? But if we're pointing out things on their credit report, or maybe we have a court order, so Blaine wins a case against, Portfolio Recovery sues Blaine's client in Tennessee and he wins and he disputes that with the court order and the bureau say, we don't care about that. Yeah, that's going to be negligent, probably willful. So in terms of sort of the fines or the damages, it really depends on how you've been harmed and if you can get to that higher level to get statutory damages, and you can also get punitive damages at that higher level. So hopefully that is helpful to you. And anything on that, Blaine?
No, I don't believe so.
Okay. So let's see. Alicia says, watch video how to read your reports. Just need to get on it. There are discrepancies. Yeah. So when Blaine and I look at credit reports, I think this is an accurate statement, Blaine. If you have 4, 5, 10, a dozen negative accounts, it is maybe not 100%, but it's like 99.9% chance that there are multiple errors on your credit reports. And so it really is worth your time to kind of dissect those reports, really study them in detail. Let's see. And these disputes go into the credit bureaus. Yeah, you have to send to the credit bureaus in order to trigger liability on the furnisher. So if you sort of visualize it like this, when you reach out to the credit bureaus, they then reach out to the furnishers. Only at that point does the furnisher have liability. And that's what's known as 1681 S2B. And there's an obligation of furnishers under section 1681 S2A. Unfortunately, you can't sue them for it. But when they're notified by the credit bureaus, now we have that section 1681 S2B. And so that allows us to sue the furnishers, and we can also sue the bureaus under that section 1681I. Think of I for investigation, and also that EB that we talked about. So here's an interesting question. Blaine, you want to take this? Why can't you sue these data brokers like MyLife who put personal information on the internet? They must buy much of it from credit bureaus. And let me see if there's any additional. Okay, I think that's it. So what do you think about that? Are those guys, are they credit bureaus, or is there some other way to get to them, you think, Blaine?
There's an argument that they are credit bureaus, but it depends on the circumstances of the individual case. I have not personally seen too many of the data brokers sued. I don't know about you, John. And I've had folks come to me about that. There's an area of the law that speaks to that speaks to the situations in which that might apply, but I don't believe in general. It's quite difficult to get to the data brokers. It depends upon the purposes for which they are selling the data, and I may let John take a stab at this, but the concept of resellers, and John, maybe you can shed a little bit better light on that.
Yeah, so let me pull up the FCRA here. So just keep in mind that simply having information on us does not make somebody a credit bureau. So if you're under 25, maybe 30, you may have no idea what I'm about to say, but there's this thing called the white pages. And we would get delivered every year this giant book that's got everybody in the city, the metro area, their name, their address, their phone number. Yeah, that was not a credit bureau, okay? But here's what the FCRA, and this is section 1681A. So this is where you get a lot of the definitions. So you say, well, what is a consumer report? Well, this tells us, it's going to be credit worthiness, credit standing, credit capacity, character, general reputation, and then which is used or expected to be used or collected in whole or part for the purpose of serving as a factor in establishing eligibility for credit, employment, or any other purpose under the. So with the FCRA, you're sort of bouncing back and forth to a bunch of different sections. But those guys would say, we're not here for employment or credit. We're here for you to check out your, the new boyfriend that your girlfriend is now dating. Make sure he's not, a criminal or something. And then if we go a little further, we can see here, this is the definition of a CRA, a credit bureau, consumer reporting agency, credit reporting agency. It's all really the same thing. Any person which for monetary fees regularly engages in whole and part assembling or evaluating consumer credit information or other information on consumers for the purpose of furnishing consumer reports. Remember, we look back up here. What is a consumer report? And then, so furnishing consumer reports to third parties. And so anyway, we have to kind of look at this. Most of these guys that you're talking about try to be very careful to not fall within this. I'll say the only advantage of them not being considered a credit bureau is the FCRA would not apply, and the FCRA has what's called preemption, which just means when federal law, so imagine this is federal law, this is state law, federal law just knocks the state law out of the way. So you can't sue for defamation and other things. Now, there's the FCRA preemption is very complicated. There's arguments on both sides, but if somebody's not covered by the FCRA, I think they get no protection from that preemption, not even the argument of it. So you might could sue under state law for unfair, deceptive practices, fraud, things like that, defamation. That may be helpful to you. Let's see here. Okay, so here is, I have a Capital One judgment from 2017 that I didn't know about and I was not served. So this will be actually an interesting question. Blaine, in Alabama, and to my knowledge, every state, but I'm curious about Tennessee. In Alabama, if you're not served, then the judgment is void. It's meaningless because due process, one of our constitutional rights, requires that we be notified, whatever that means under state law. Okay. And I'll come back to that in a second. We have to be properly served or the lawsuit's just no good. So I've had people that have judgments from, 15 years in the past, and that thing is like doubled and doubled again. And we go in and show that we were not served, judgment goes away. Now, it doesn't make the lawsuit go away, but it makes the judgment go away. And the final thing I'll say, then I want to hear about Tennessee, is being served does not necessarily mean you get handed the papers. That is one way to be served. But for example, in Alabama, let's say that you live in a house with a roommate and somebody knocks on the door, hands the paper, the lawsuit to your roommate, and then your roommate promptly shreds it and never tells you about it. You've been served in Alabama, even though you don't really know about it. They have to meet the requirements of service. So that's why, I would say to you, make sure you know what the requirements of service are in your state, and certainly get with the consumer lawyer in your state to see what your options are. So, Blaine, is it the same rule that lack of service means the judgment's no good?
Absolutely. And Tennessee is in, Alabama is in, I don't like to guess, but nearly every state, lack of service is fatal to a judgment. There's a there's a Latin phrase, void ab initio. It means it is void. It's something that it's as if it never happened, according to the law. It's just not there. And in Tennessee, in order to get a money judgment, and it's so funny that this came up. I had a conversation with a collection attorney. Imagine that, this afternoon. And we were talking about service. And he said, you and I both know that without personal service, it never happened. It's dead. It's no good. And that was in a case where a client of mine had their identity stolen and a loan taken out. And of course, there was a judgment, but there was no service. So there was no judgment, and it had no real effect. But it's very important that you talk to someone like John and someone like myself and look at it closely, because as he said, he correctly pointed out, you may believe you weren't served because you didn't physically see it, but there may have been someone of suitable age, as the law says, of suitable age and discretion in your home. Could be a spouse, could be someone else. And it's possible that could be determined by the court to have been adequate service. So, but in the event you actually were not served, then that judgment would mean nothing in terms of your having to pay.
Yeah, and I will say this, just pick up on something Blaine said about a court may determine. So there's a judgment. They certainly can garnish your wages. They can garnish your bank account, put liens on your property. You would have to attack that judgment and have the judge rule the judgment is void. So what Blaine's talking about is it is void ab initio, but you have to have a judge say that. So we don't want you to think that you can just go, well, I wasn't served, so I'm going to ignore this. That would be a very bad mistake.
Your attorney would have to file what's known as a motion to set aside or a motion to quash. And that's big fancy law language for, hey, the court looks at this and says, this is no good. Let's get this off the books. That didn't count.
Yeah. So let's see here. We have, going back to credit reports, when you dispute an account, the bureaus are supposed to add a statement you are disputing. If they don't, is there a recourse to that? So it's more of the furnishers are supposed to tell the bureaus that the account is being disputed. It gets a little complicated because let me sort of share this with you. Most scoring models will ignore an account that says disputed, so it doesn't hurt your credit score. Well, if you're trying to get a mortgage company will say, yeah, that's cute, but we're not going to allow you to apply if you don't have all of those accounts undisputed, because we want to apply the score. So what some of the bureaus have started doing is they'll put language in like, Blaine, this was disputed, but now it's resolved. Well, what does that even mean? There's an open question on that. Is that valid? Now, the bureaus will also say you can write a statement, like a 100-word statement or 200-word statement. It really doesn't do anything. I had a funny case where the bureau said that my client was dead. Well, he was a little offended by that. And so he disputed it and said, I'm alive. And they wrote him back and said, we've investigated it and you're dead. But if you disagree, you're welcome to add a 100-word statement. So I sued the bureau and put that the bureau apparently thought my guy from beyond the grave could write a statement. And I thought that was pretty funny. The lawyer for the bureau did not have much of a sense of humor about that, but the judge liked it, thought it was funny. So, this idea of a statement or disputed notation, the disputed notation is really the important thing. And that's more of the furnisher. It has to be what's called a bona fide dispute. So you have to have some good basis for it. But that can be a claim that you make. So definitely worth checking out there. So here Wesley says, I live in Texas. Can you sue from Alabama? So this is what Blaine and I, we get a lot of people from different states. And I'll give you kind of my take on it, and then Blaine can add anything to it. There's a couple possibilities. First of all, we always encourage people, get a lawyer in your state. That's always if you can find a good lawyer who knows what he or she is doing, that's always going to be your best bet. Sometimes we'll take people from other states and we'll file the lawsuit in, for example, Alabama, or Blaine will file it in Tennessee. Mm-hmm. The danger with that is they may be able to transfer your case back to Texas or somewhere else. Okay. The other option is we get a lawyer in your state to what's called co-counsel with us. And if they're admitted to practice in, for example, Texas, then they get for me to be admitted there for this one case. The fancy word, we have all these Latin words. I don't know why. I was never good at Latin, but pro hac, okay, just means you're in the case for,
right.
You're admitted for one case. And so Blaine can do that in other states. I can do that in other states. But our first recommendation, and I think this is Blaine's recommendation too, is try to find a lawyer in your state that does this type of work. You have any additional stuff for that, Blaine?
Yeah, I would say that. And then look, if you're not certain, and you just really feel like let's say you go to the Naca website, which I believe is www.consumeradvocates.org, and you go to the Find a Lawyer tab. It can be confusing. You may find so many attorneys that you really don't know. You think you've got it narrowed down, but you're just not sure. Call one of us, and we know folks in lots of states. And for instance, in Texas, John and I both know multiple individuals. And what we will do is send you down there if it's a large, complicated case. We may even co-counsel with someone and work as liaisons and do other work on the case. But the main thing is don't worry about asking questions. If you're not sure and you go and look, we'll try to help you find someone in this state where you live. There's always an answer. Just be sure and reach out to one of us or someone who works in the same capacity that we do.
Very good, very good. So this is Sam back on that cease and desist, and so he said LVNV honored the cease and desist. Well, that's good. They finally did something right. I'm proud of them for that. Let's see. Eric says, if I get sued by a debt collector for an old debt that I've already settled, do I need to hire an attorney to resolve this? So, Eric, I will say this, that if you can show that the debt, so, account number 1234 with Capital One, that you settled that debt, whether with Capital One or with the collector, and now another collector or the same collector is suing you, you absolutely need to get a lawyer, because you need to win this case, and then you need to absolutely blister this debt collector. So I'll just tell you this, when we have those types of cases, our settlement demands start in the six figures. Okay. Mm-hmm. So if they're suing you for a debt that you've already paid, and you can show, particularly this debt collector knows it. Like, I've had a client sued and we win, and then the same collector sues us again on the same debt. Now, that's hard to explain. They always try to go, oh, it was just a simple accident. Like, how do you sue me twice for the same debt? But I would absolutely get with somebody. And again, if you don't know anybody in your state, feel free to reach out to us. Or if you happen to be in Tennessee, Blaine will gladly talk with you. And if you're in Alabama, I'd be glad to talk with you as well. But here's the critical thing. Do not ignore that lawsuit. Okay. I've seen people say, well, wait a minute, I've already settled this. I don't have to worry about it. Boom, they get that judgment against you. Goes back to what we talked about. Did they serve you? Yes. Did they get a judgment? Yes. Well, now you owe the debt. Okay. Because the judge just said you owe it. And so you definitely want to fight and win that case. And then you want to look at suing whoever's responsible for this fiasco. So, Blaine, those are cases that we love to get, right?
Yes, John. Eric, for your information, I was looking frantically on my keyboard for the home run emoji. Because you have that in that scenario, the ball has gone out, over the fence into the parking lot, or maybe it's like the Giants and it's out there in the bay somewhere. But that is, don't ignore it and make it more complicated. Doesn't mean you would lose your case if that happened, but it could greatly complicate it. So look at that and address it head on. And as soon as you can.
And the last thing I'd say about it is sometimes we have clients come to us and say, hey, I've already paid this debt. Now I'm being sued on it again. It turns out it's not the same debt. It may be a portfolio recovery for $750 and now you're being sued for $780. Well, it could be a different account. Could be a Synchrony bank account, but you may have had multiple ones. So we always kind of take a step back and go, okay, let's really look at this. What exactly did we settle? What paperwork do we have on? It's another reason to pull your credit reports from annual credit report as often as you can. As Blaine and I are recording this, it's once every 7 days. Even if you say, well, I don't know exactly what I do, like put them in a file, put them on Dropbox or Google Drive or whatever, because you never know when you might need to go back and say, what was that account back 3 years ago, with portfolio recovery or LVNV funding or Midland Credit Management. And you just want to tie together, like this is indeed the same exact account. And, here's, Eric, is a very fancy legal expression. So Blaine and I both went to law school in the South. So I don't know if they would say this in other places, but this is what we would say. Somebody's got some splaining to do, okay, for why you're being sued on a debt you've already paid.
Y'all got a problem.
Yeah, that's right. So let's see. Newman, thank you guys. Answer my questions. This was on the credit scoring. Use strategies, now FICO. That's fabulous.
Well, in the last 45 minutes.
Yeah, that's amazing here. So I think I need you to help me get my FICO score to 775. So what a waste of credit score goes away. Yeah, I don't think you're going to have to worry. You're going to be able to like enjoy and use and just, know that you have that really high FICO score. So that's fabulous. Let's see. Victoria says, if you notify the bureaus that information's incorrect and show them, isn't it willful when they continue to report? That's a very logical conclusion, and it should be the answer. And sometimes it is, but some of the courts sort of give cover to the credit bureaus and say, well, this was negligent. But as long as they can sort of make an argument with a straight face for why they somehow believe that this was okay, some judges let them off the hook. Now, I think the trend is recognizing these guys are, when I say these guys, I mean the credit bureaus half the time are ignoring our disputes. And when, for example, we have a number of cases where our client wins the collection lawsuit and then we dispute through the bureaus, say, here's a copy of the lawsuit, here's a copy of the order, and the bureaus don't fix it. We certainly take the position that is willful. You have a judge saying this case is over, Joe Blow won, and the bureaus are like, yeah, we're going to keep it on your credit report. Well, I think that's willful, but it also depends on who's wearing the black robes there. So let's see here. Eric, check my local county court website. Virtually all cases either end in dismissal or agreed judgment. Don't see any dismiss with prejudice. Something different about Texas. So I am not sure, but I will say this. You might have to dig into the details a little bit. It may just say dismissed, but you might have to look and see, is that dismissed with prejudice or without prejudice? I think Texas uses that expression. Basically, with prejudice means it's over, it's done, it's finished. Without prejudice, it's like they never sued you. But you will find almost all cases end in a consent judgment where the consumer agrees to a judgment, or a default judgment where they don't do anything and the other side wins by default. It's pretty rare to see a dismissal with prejudice because most people just don't take any action on this. So I'm assuming, Blaine, that's the same in Tennessee.
That's absolutely the same. It could be as simple as the notation in their court reporting system that they have. If you look at the front of the front page of a civil summons, which is the charging document that we use instead of a complaint in civil sessions in our lower courts in Tennessee, there are two check boxes, one with prejudice, one without. And the vast majority of the time, when let's say that there's an agreement, the person doesn't have an attorney, they don't have someone like John or myself, and they come into court, the judge will say, now you go back there, sir or ma'am, you go back there and talk to the nice gentleman or the nice lady and work something out and come back up in front of the court and we'll get it entered. Usually what happens is the court will enter some sort of a dismissal with prejudice at that point if they enter into an agreed judgment to indicate that the suit is satisfied. But frequently, if you hire someone like myself, at least in Tennessee, it may be different in Alabama. Sometimes the mere fact that you've come to an attorney and your attorney shows up on your behalf on the appearance day, frequently they will be concerned enough that they will go ahead and dismiss, but they will do it without prejudice, which means that they can come back at any time within a year of that dismissal and sue you again, at which point you're back seeking the help of counsel.
Yeah, so one thing that you can try and do to stop that, there may be a counterclaim that your lawyer can file.
That's true.
Against the debt collector. And sort of think about it. Some states allow the bad guys here to just like dismiss without prejudice. I think in Georgia, maybe they can do this even in the middle of trial. Alabama, it's up to the judge, but most of our judges won't let them dismiss without prejudice once we've answered the case. But in some states, you may need to file a counterclaim to sort of like wrap your hands around the other side, to be like, they go, okay, we want to go away. And you're like, no, I'm not letting you go. We're going to get this resolved, because you don't want to just be repeatedly sued for the same debt. Here's an interesting one, Blaine, if you'll take this. I have a fraudulent charged off account that is reporting on all three bureaus. The original creditor and the collectors have both closed the account and asked the collection agency stop reporting. That may mean the credit bureau to stop reporting, but they're still reporting. They even have a letter saying the account's closed. What can I do? So let's assume these are the facts. It's identity theft, and this person has spoken with the original creditor, spoken with the debt collector. Everybody's like, yeah, this is not your account. How does he or she get this off of their credit report?
Well, the first piece of advice I would give you is that you need to write a detailed dispute letter. And then you also need, before you send that off, you need to fill out as accurately as possible, with as much detail as possible, a Federal Trade Commission FTC identity theft affidavit. Also, if possible, you may want to, depending upon the circumstances, many times you may want to file a police report. Now, the police will not take you. It's going to be frustrating. They're not going to maybe take you seriously, but they'll do an informational report. They likely won't open a case against anyone. But you want to have those items ready if possible, and then make a very, very detailed dispute letter and send that to whichever one of the credit reporting agencies are reporting, and that will put them on notice. I will let John add whatever he wants to that. But those are the first things that I would do, and if I notice that, I would not delay in seeking the help of folks like us, as that is a fairly serious situation.
Yeah, and what I would say is, you do all that, include that letter that sounds like you have from the collector or the original creditor. So just give the bureaus everything, and it should be taken care of. It's only when the credit bureaus get really foolish that they don't take off identity theft type of accounts. So you should be okay on that. Let's see, somebody from Facebook, not sure who that is. Good to see you guys. Well, we appreciate it. And we will we'll need to wrap this up here in just a moment. But Blaine, if you got another minute, let's see if we can crank through these.
Absolutely.
Let's see, live in Atlanta, Georgia, can you recommend a consumer lawyer think is good? Yeah, I would recommend Steve Koval. Let me see if I can put this. I'm not sure exactly how this will show up. It may be sort of a mess. I just copied. Yeah, that didn't come out quite like I want. But anyway, Steve at covalfirm.com, and phone number is 404-513-6651. And he's a real good guy there in Atlanta. Let's see. Cosmo Martinez, I have a question. What should I do if they close my account and I'm still paying for it? I do not want to get more late payments. Should I settle for that account? What other option do I have? So it sounds like maybe this person's late right now and they've closed the account and he's still paying on it. I mean, you could settle it, but they can continue to report you as being late as long as you're late, or if you're charged off, as long as you're charged off. So, if you have the ability to settle and it's a good deal for you, and then it may be very much worth it to settle it now to try to kind of stop the bleeding. It may not come off your credit report, but at least you won't have any further reporting. And then again, I would encourage you, look at all the reporting on that through annualcreditreport.com, each of your bureau reports, and see, are there any errors? Because that can give you a basis to dispute. And let's see. Eric says, is a judgment that is released the same as a dismissal? So in Alabama, the answer is no. So in the sense that it's still a judgment, it's just been satisfied. But there still is a judgment against you. You just don't owe anything else on it. That's not the same as a dismissal, which means there's no judgment against you. Is that the same in Tennessee?
It is. The term in Tennessee is satisfaction.
Okay.
So once there's a satisfaction of the judgment, typically what most of the collectors do, they may send into the court a notice of satisfaction of judgment, and many times that will be recorded in the record. But it doesn't mean it never happened. It's not that clean. It's a cleaner slate, but it's not a completely clean slate, if that makes sense.
Yeah. Let's see. Is it worth it to sue the credit bureaus if the credit bureaus eventually update your credit report violations after the 30+ day period? So it's a really good question. So let's kind of get our timeline. So you dispute and they receive it. They have basically 30 days, sometimes 45 days to investigate. And then they're supposed to send you the results of investigation. Hey, we fixed this. We deleted it. We're not making any change, whatever it is. So at that moment in time, if they have done a negligent investigation, you can sue. Now, personally, I generally want to, make sure they get my dispute. We get those results of investigation. And then maybe 2, 3, 4 weeks later, we pull a new set of credit reports and see, have they made the changes? But the wrongdoing is locked in when they do the negligent investigation. Now, they may fix it later, and that may sort of bring your damages down, but it doesn't make it go away. So maybe a poor illustration, but if I run a red light and crash into Blaine, the what's called the tort or the cause of action, it's complete then. Now I may help him out and patch him up and that's all great, but it doesn't change the fact that I ran the red light and crashed into him. So you have to look at it and see how big of a deal is it that they did a negligent investigation, even though they may have fixed it later. So there's no just one answer I can give you. I'll say I have sued on that before, and there are times where I have not sued on that. And let's see. So we've got love your content. Well, good. We're glad that you're getting some value from this. And let's see. Do not have a late payment, but still paying on. Okay, this is one that's closed. Yeah, you just want to make sure that don't let that get behind if at all possible. And you should be Very good. And I think we're almost done here. Is there any adverse effect of having a judgment, even if it's satisfied? So judgments used to report on credit reports. We really don't see that anymore. There was a settlement with attorney generals that, I won't say it prevented all of them, but almost all of them. It could be negative in the sense you're applying for a mortgage and they say, have you ever had a judgment against you? Well, you need to answer that honestly if it's just been satisfied. So, but I don't think it would have much effect, and maybe no effect at all if it's satisfied. What's your experience with that, Blaine?
No, that's true. We used to call that a gray mark. It's not good, but it's not horrible. I would not spend a lot of energy worrying about that. At any rate, it has happened, and you've got it behind you now. If later on that pops back up and it's somehow reported inaccurately, or begins to be reported again, then maybe that's an issue then. But I think John is correct in the way he's advised on that.
So then the last one we will do is the law firm who informed me about the judgment. I think this is the judgment from 2017 when he was not served.
Okay.
Or she was not served, is not the same as who filed for it, but they have the same address. So sometimes law firms change their names, and sometimes one law firm will get the judgment and then it will be sent to a different law firm to actually collect on that. It doesn't particularly matter about the law firm. The real question is going to be, were you served? And you could ask the law firm, or you could go to the court record and say, can you give me whatever the document is showing I was served? And there should be what's called the default judgment, motion for default, application for default. The different states call it different things. But usually in that's where they're asking the judge to enter a default judgment. They normally have to show how you were served. And so you could do that. I would recommend get with the consumer lawyer in your state to handle this for you, just to look at it. And we do this in Alabama. We'll say, yeah, let's pull the court record and hey, here's the green card they say you signed, or here's somebody says they served you on this date, this time. Can you prove that would be impossible? So I've had people that we've been able to go back and get their medical records and show that they were in surgery when they were supposedly served. Pretty confident the process server did not barge into the operating room, and like put the papers in the patient's hand. Okay. And so when we show that, they always back off, or, show that you were out of state that day, or they say they served you in Shelby County, Tennessee, but you can show that you were at a conference in, Chattanooga, Tennessee. I think Shelby's Memphis, right?
That's correct. That's correct.
So opposite sides of the state. So you just want to be able to show that. So find out how they say you were served, and then can you prove that it's impossible? Certainly you could say, well, I wasn't given the papers, but it's more persuasive to a judge when you can say, look, there's no way I could have been given the papers. I was, in the military, and Kuwait when they supposedly served me, or whatever the situation is.
Well, and that was such a problem with military, and I live in a military town. Fort Campbell, Kentucky is right there, adjacent to Clarksville, Tennessee. And for many years, soldiers and other service members in various branches would get sued when they were in overseas, either in active war or just on a duty station. And so there's this act known as the Service Members Act. And that was such a problem that they actually had the Department of Defense set up a database. And there's actually a database where collectors are supposed to go. They're required to go and check to see if the person being sued is an active duty member of the armed services. So this is, as John said, this is all about service. You may want to look in what's known as the rule docket in your case and see. You might be surprised. I've got one I'm working on right now in Nashville, where the real docket shows my client. It says not served, not served, and yet there was a judgment taken against my client's sister, and also, even though the judgment didn't go against him, the collector is coming against him, knowing, or at least able to say that they know that he was not served. So that goes back to that earlier question. The judgment is valid against the sister, but it's void as against the person who wasn't served. So you really want to do your homework on that, and you should be able to reconstruct possibly from your calendar or your emails and such where you were at the time that you're alleged to have been served.
Yeah, and just one last thing on that. You sort of want to think this through to say, what possible argument could they make? And I'll give you just one example. This was a guy, he had a judgment from about a decade before, and he said, John, I lived in Texas at the time, and he was supposedly served in Alabama. And I said, well, can you get pay stubs to show when you were working? Because he worked at a factory. And so he was able to show that. So we could show he was working on the day he was supposedly served in Birmingham. He's working, 2 hours outside of Dallas. But we were talking and said, well, it's theoretically possible you could have got off work, run to, Love Field, jumped on a Southwest flight, landed in Birmingham, been served, jumped back on a plane, flew back to Dallas, got home, and then went to work the next day. Now, that's unrealistic, but it's possible. So we're kind of building this thing and saying, well, there's a slight little vulnerability here. So do we have any proof that we did anything that day? And it was amazing. This guy actually had receipts from that day. Like, here's where I bought gas. Here's where I did this. And so I laid all that out to the judge. The other side saw it. They're like, you got to be kidding me. Like, we give up, So we were able to show it's impossible to have been served. So it's not just my client saying I wasn't. He certainly would say that. But we could show the judge, like, you don't have to believe my client. Look at the evidence. And so, they may say they served you at this old address. And you're like, no, I stopped living there 6 months before that. Well, here's my new lease. Here's where for us, we can just ask Alabama Power or Alagasco or these other places, these utility companies, like, when did I shut off my utilities? They'll send you a letter back. Boom, here's when you shut it off. So you can say, see, I wasn't even there. And so that can be helpful. So you just have to try to think through, is there any possible way they can argue that they did serve you? And let's see here. Thank you. Appreciate you guys. Content is helping. Well, that's good. That's why we do this. We want it to be helpful. And
it's been helpful. Tell folks about us.
Yeah. And Eric says, thank you. You're very welcome. And this will be our very last one. Looked at court records 2018. They said they tried to serve me in person. No one was at home. It was a lie. We're 10 people and 5 of us always home, including myself. So this may be what happened. They said they tried to serve you, and the judge may have let them do a service by publication. That's where they put it in the newspaper. It's pretty extreme. But just what you're saying in Alabama, it sounds like they didn't serve you. And so you really want to dig in. And again, what I was saying before about you want to sort of cover every possible avenue that they could be successful in. And so, if you're like, well, I haven't looked at the rest of the court file. See, the rest of the court file could have something damaging to you. So you want to look at that and sort of get all the facts out on the table and then say, can I show the judge it's impossible for what the other side said happened actually happened? And so, well, let's do this. Let's see. Oh, it says they mailed it. So you would have to know, is service by mail proper? So in Alabama, regular mail is not. Certified mail is, but you have to sign the green card or your agent has to sign it.
Mm-hmm.
So again, you need to know what the laws are in your state. And thanks, John. Blaine, you're very welcome. Blaine, if somebody wants to get in touch with you, what's the best way for them to do that?
Well, the The best way is to send an email to B Dixon, BDIXON, at usconsumerlaw.com. B Dixon at usconsumerlaw.com. And if that doesn't work, you can call my business mobile at 615-440-3746.
All right, everybody. Thanks for your great questions and your interest. And we will see you again, hopefully in a couple of weeks. So everybody have a good evening.